Much obliged, Your Lordship. Your Lordship, a permanent injunction is a restraining order putting an end absolutely to certain acts being conducted by whatever person it is being sought against in the circumstances.
Okay, thank you so much, both counsel. We shall now proceed to hear from the respondents. Please proceed. You can give them the mic.
May it please you, my lord, for record purpose, Chigos Herbert, the Attorney General of the State of Insiche, appearing for the record. My lord, the respondent for you, the web of lies that have been carried to this honorable court by the applicant. My lord, I'll go straight to the lies that have been brought to this court about jurisdiction, my lord. My lord, it's true that application is brought under Article 50, Constitution of Insiche. However, my lord, the Constitution of Insiche, in the case of versus was articulate on the duty of the Constitutional Court in relation to Article 137. Matters that in the Constitutional Court are those matters that relate with the interpretation of constitutional provisions, my lord.
So what are we dealing with here?
My lord, here we are dealing with matters that relate to enforcement of human rights. And my lord, if you are to go to the Constitutional Court is specific, they are only either constitutional references or constitutional petitions. And by the virtue of the well-stipulated law, under Rule 7, Sub-Rule 2, it is the Constitutional Court that is mandated to hear this matter. My lord, in the most recent case of the Legal Brain Trust versus Attorney General, it was clearly stated, even though as Counsel Festo was submitting, he lied to this honorable court that actually Justice Musa Sekana upheld the jurisdiction of the High Court in relation to handling matters of public interest litigation. My lord, if you would permit me to read an excerpt from this case. From the applicant's pleadings, it is very clear that the applicant seems to seek to enforce public interest actions on behalf of the people of Uganda. This court does not therefore have jurisdiction to handle it, and as the right forum under Rule 7, Sub-Rule 2, for the orders and the relief sought in this constitution, sought in the Constitutional Court as stated above. My lord, these are some of the web of lies that have been carried to this honorable court by the applicant, and therefore it is the respondent's submission that this court has no jurisdiction to handle this application, and therefore it is not admissible before it. My lord, if I have no further indulgence, permit me to go straight to issue 2. Issue 1 of the application. My lord, as to whether the failure of the state to provide access to information through age-appropriate sexuality education was a violation of the constitutional rights of citizens, especially young people, and the international obligations of the state under applicable instruments. It is a responding submission that the state of Insiche is alive to the obligation. The state of Insiche is alive to the obligation that that is vested to it by the Constitution under Clause 2, under Article 20, Clause 2 of the Constitution, to uphold all rights granted under Chapter 4 of the 1982 Constitution of Nsiche. However, my lord, the same Constitution provides for basic education under Article 34, Clause 2, which the government is mandated to provide. And it is very clear in the facts that it is the Ministry of Education and Sports that is mandated to coming up with maintaining and drawing the curriculum that is supposed to be followed by the pre-primary, post-primary, and primary education, as per the provisions of Section 4 of the Education, Pre-primary, Primary, and Post-primary Education of 2008. And my lord, in the education system of Nsiche, the students or the children have a chance to learn, to have information about sexuality education. How? In the primary level, we have science that is taught to pupils, and this entails the reproductive system and the menstruation cycle, just to mention but a few. In the secondary education system, we have biology, and it covers properly all the information that relates to sexuality education, my lord. And my lord, the applicants are not allowed to the fact that Nsiche is a low-developing country with very limited resources that are supposed to be utilized among the 39 million people that are in Nsiche. The principle of progressive resource utilization is applicable in this context, my lord. How? Given that there are few resources that the state of Nsiche has, it must put those resources to areas where there are no services at all, in order to realize that all other rights are equally promoted. My lord, the right of access to sexuality information, we have already avenues through which children and young women can access this information as discussed above. My lord, it is therefore the applicant's submission that the state of Nsiche has not neglected its duty of providing information to the young people of Nsiche. My lord, when you look at the provisions of Section 15 of the Education Act, allow the application of customary law. And my lord, the state of Nsiche and its culture, there is a tendency, there is a practice of parents or guardians, to be more specific, the Sengas and the Koja, who pass on this information about sexuality education to the young people. Therefore, it is the responsive submission that the state of Nsiche has vast modes through which the children of Nsiche can access information in relation to sexuality education.
So, Council, why would justify why this court should go ahead and enforce the culture or the cultural practice complained of?
Much obliged, my lord. However, that is an issue too, but let me submit on it. My lord, about the cultural practice, Article 37 of the Constitution of Nsiche grants the right to practice, to everyone to practice their culture. And in this case, the people of Entumwa have the right to practice their first Echinihiro Lujaburantongo. And in this case, my lord, the applicants have not in any way connected the organizers or the main theme of the Echinihiro Lujaburantongo as the one that is intended to molest young girls. Further, my lord, actually, this fest is of advantage to the people of Insiche. How? The girls who are supposed to carry the calabash as they celebrate their king, their god, Kaumpuli, are those virgin girls, my lord. With the esteem of practicing your culture, who would not want to be part of the virgin girls who will be carrying the calabashes? What does this promote? It promotes purity among the people of Entuma tribe. And therefore, my lord, when it comes to limitation of a right, the Constitution, the Supreme Court, in the case of Charles Onyango Bo and Andrew Mwenda versus the Attorney General, was very clear. The limitation must be that which is the most justifiable in a free and democratic society. My lord, I pray for 5 minutes to submit on issue 2.
How many minutes have they used so far? How are you going to, because you have only, he has 15 minutes, so how are you going to share the...
My lord, I was supposed to use 15 minutes.
Mm-hmm.
He's supposed to use 10 minutes, then you are going to use 5 minutes for rebuttal.
But remember, you're going to be assessed individually. So if he consumes most of the time, it will be to your advantage. But I don't want to disrupt your arrangement. You can proceed.
The 5 minutes are granted? Yeah, you can proceed. Thank you, my lord. My lord, on issue 2, about as to whether the failure of the state to pass a policy on sexuality and on sexual and reproductive health and the right to protect vulnerable groups of people from harmful cultural myths and practices was a violation of human rights guaranteed under the Constitution and applicable law. My lord, the state of Insiche is the state that has 3 arms of government, with each arm of the government having mandate on what to do. This is referred to as the principles of power, separation of powers. And my lord, the applicants bringing to this honorable court a matter that requires formulating a policy is only to sabotage the principle of powers of separation, because that will amount to a political question doctrine where the judiciary is going to intermingle with the activities that are only mandated to the executive as per the provision of Article 111 of the 1982 of the Constitution of the Federal State of Insiche. My lord, the applicant submitted that the Congress never considered the advice that was given by the head of Sohadi. My lord, the case of my lord, the case of Ibrahim Daimulira versus Attorney General Miscellaneous Application number 24 of 2015 is very clear on this. What is meant to be contested is not the provisional bill that is being debated under the Congress, but rather the Act. If indeed the law was to give way for the contestation of the bill that is before Parliament, that will also tantamount to violating the principle of the powers of separation. My lord, the state has not delayed or has not neglected its duty of coming up with a policy, but it is taking adequate time to come up with a policy that is going to meet all the requirements that are in the best interest of the people of Insiche. And it is very clear from the facts that a prohibition of certain actual bills, a prohibition of certain actual act bill is before the Congress. And my lord, the Congress has also indulged or has also tried to bring on board the civil societal organization through which the head of Sohade was able to bring his advice of including as a section that relates to the provision of sexual and reproductive health. And my lord, it is very clear that the government is on track of bringing up a policy that best suits the culture of the state of Insiche. My lord, therefore, it is a respondent submission that the state has not violated its mandate of coming up with a policy in relation to sexual health, sexual and reproductive health. I beg to stop here, and I invite my colleague.
Council Tumwesije, please proceed.
Much obliged, my lord. May it please you that I proceed with issue 3 and issue 4 as the respondent submission is providing. My lord, issue 3 is the effect of whether the failure of the state to provide and ensure the essential training and information to girls, young women, and vulnerable groups and institutions on sexual and reproductive health and rights was a violation of the human rights guaranteed under the Constitution and applicable law. My lord, I would like to respond to this issue in reference to the well-established principle of progressive resource realization under Section 13 of the Human Rights Enforcement Act of 2019, where courts call upon institutions of government to ensure that when they are upholding the rights of individuals, they pay keen attention to the principle of progressive resource realization. My lord, from the facts of this case, it is not in contestation that the Federal Republic of Insiche is not a developing country. It is a country that is growing. It is a country that has meager resources, and as a result, the respondent would submit that when the state is called upon to ensure that there is a policy on sexual and reproductive health, in as far as the contestation of the applicants is concerned, the state has to be alive to the resources available to it. Let us look at the budget itself. The budget is normally passed. So what does the budget provide for? We shall not, as the Federal Republic of Insiche, cough money that we do not have. The resources that are available are those that provide for basic education. My lord, this is buttressed under under the interpretation section of the Education Pre-Primary, Primary and Post-Primary Act of 2008, and even Article 34 of the Constitution also mandates the government to provide basic education. What the applicants are contesting for is comprehensive sexuality education. In as far as the two are concerned, they are distinct. Basic education is different from comprehensive sexuality education. It is the applicant's submission, the respondent's submission, your lordship, that may this honorable court be persuaded by the principle of progressive resource realization, a principle that her ladyship, Lydia Mugambe, expounded more in the case of Legal Brains Trust versus Attorney General, a recent decision. He said, yes, however much the country which is neighboring in Siche, Uganda, has failed to realize the policy relating to sexual and reproductive health, but it should not. It should also be alive to the progressive resource realization principle. The same, my lord, has been espoused in the case of Sabromani from South Africa. The court of South Africa expounded that when states are looking at the rights that are under their various provisions of the law, they should be alive to the progressive resource realization principle. It is a key tenet of any democratic society, my lord. If the Federal Republic of Insiche was to run to each and every issue, then some sectors of the state would have been left out. And as a result, we are submitting before your lordship that in as far as this issue 3 is concerned, may this honorable court be persuaded by the principle of progressive resource realization. Whatever the applicants have submitted upon your lordship, in as far as issue 3 is concerned, I am praying before this honorable court that may that issue be answered in the negative, whereas the respondent's issue may be looked into in the affirmative aspect. My lord, I would like to handle issue 4, which is to the effect that, whether the failure of the state to investigate and prosecute the violators of the sexual and reproductive health of the girls and provide healthcare services for the victims was a violation of the girls' rights guaranteed under the Constitution and applicable law. The Federal Republic of Insiche would like to concede that yes, it is its duty, pursuant to Article 120, the DPP is entrusted with powers to prosecute. That is a conceded factor. But again, your lordship would like to submit, in reference to this issue, we are not dealing with adults here, we are dealing with juveniles. Your lordship, I would like to rely on Rule 6 of the I would like to rely on Rule 6 of the Beijing Rules, which provide, which confers upon the state parties discretionary powers on how to handle issues relating to juveniles. Your lordship, we are alive as the respondent to the fact that in as far as the Beijing Rules are concerned, they provide, my lord, with your leave, I intend to read it verbatim. Much obliged, my lord. Rule 6 of the Beijing Rules provides that discretion shall be exercised appropriately at all stages of proceedings and at the different levels of juvenile justice administration, including investigation, prosecution, adjudication, and the follow-up of dispositions.
What is the domestic law of Insiche that governs prosecution of child offenders?
Much obliged, my lord. The domestic law is the Children's Act, Cap 59, as amended, particularly under Section 89.
Is it the Children's Act or the Children Act?
The Children Act, my lord.
Mm-hmm.
The Children Act under Section 89, my lord, is the principal law, which of course is in tandem with the Beijing Rules, my lord. And the state of Insiche is alive to the fact that having Section 89 having been in tandem with the Beijing Rules, my lord, it is again the discretion of the prosecution, the Federal Republic of Insiche, to choose how and when to come up with, to make sure that these child offenders are culpable. Mind you, my lord, I would like to respond to the same, that in as far as Rule 6, Sub-Rule 1 is concerned of the Beijing rules, it provides that efforts shall be made, however, to ensure sufficient accountability at all stages and levels in the exercise of any discretion. My Lord, from the instant facts, the Federal Republic of Insiche considered that yes, it is the one that is constitutionally mandated to handle such issues. But again, when it is doing so, it has come up with, from the facts, my Lord, investigations are still being conducted. My Lord, the Federal Republic of Insiche does not want to risk to be back in this honorable court for the violation of the rights of the child. The African Charter to the welfare and to the welfare of the child is very articulate. We do not intend to be back in this honorable court, my Lord, pertaining issues of violations of child offenders. So we are taking our time as the Federal Republic of Insiche to ensure that we conduct proper and prompt investigations, evidence, then we appear before a court of competent jurisdiction. With that issue being handled, my Lord, I pray that it may be answered in the affirmative, whereas the applicant's submission in relating to issue 4, my Lord, I pray that it should be answered in the negative, and the declarations that they have sought for should be denied or declined. I so submit, my Lord.
Okay, thank you, Counsel Tumwesije. Do they have any minutes they didn't use? How many? 1. Please, you have 1 minute.
Your Lordship, the respondent's case suffer from lack of particularity and focus. Your Lordship, I would like to bring it to the attention of this court that the decision in Legal Brains Trust Limited versus the Attorney General, miscellaneous application number 314 of 2021, the applicants relied on the decision that the High Court is vested with jurisdiction to entertain matters regarding personal or individual violations of the citizen's rights, but rather not public interest. And Your Lordship, in the same regard, the Constitutional Court is mandated to handle matters of constitutional interpretation under Article 137 of the Constitution, rather not handling matters of adjudication over violations of rights of the citizens. And Your Lordship, our submission regards to the same is that any act of Parliament cannot host the jurisdiction of the Constitutional Court, and this was held in the case of Rabo Enterprises versus Uganda Revenue Authority. It was a civil appeal to the Court of Appeal, where the justices of the Court of Appeal held that an act of Parliament cannot host the jurisdiction vested on the court by the Constitution. And to that end, we humbly submit that the respondent's averment in regards to jurisdiction be dismissed and not regarded by this court. And Your Lordship, the respondents have misled this court by citing Legal Brains case and also citing Justice Mugambe, and that the case was on passing policy or sexual reproductive rights. But Your Lordship, that case is distinguishable from the circumstances because it basically handled jurisdiction. There was nothing like policies or sexual rights in that case. And Your Lordship, the respondents have relied on the case of Charles Onyango, Bwanda and other versus the Attorney General to the effect that the limitation in the circumstances and Article 43 of the Constitution, it has to be demonstrably justifiable in a free and democratic society in the circumstances. And Your Lordship, when you retire to deliver your ruling, the question to be posed is as to whether the respondent's actions satisfied that test. And in our respectful submissions, we submit that it did not. And this is pursuant to paragraph 10, to the effect that the respondent went ahead and impeded the initiatives which had been taken by SOHAD to ensure that the citizens are granted or are given essential training in the circumstances. Much obliged, Your Lordship.
Okay, thank you, Counsel. The court is stood over for 3 minutes. So I want to congratulate both teams for putting up a spirited fight. I know it's a competition, but it's also a learning what? It's also a learning process, okay? So take heart. A few observations. Both teams assumed that I know their case. I don't know your case. Applicants, I don't know your case. Respondents, I don't know your case. I remember in the morning I gave you a brief and I told you that it is always very good to stick to the basics. To stick to the basics. You went straight into the submissions. I didn't hear the applicant's facts. I didn't hear the applicant's issues. I only heard resolution of your issues. The two are different. I didn't hear the respondent's facts. I didn't hear the respondent's issues. I didn't hear your law applicable. You only went into the resolution. So always stick to the basics first. Don't be taken up by the events. Stick to the basics. If it was a written exam, all of you would have missed out on those. I think they're normally 5 marks or 10 marks. You would get a 0 there. And that really led me now into having to get your facts from the applicability of the law. Yet if you had given me a clear set of your facts and a clear set of your facts, that helps a judge to appreciate your case. Then too, it is always good to know your strength. The applicants, I believe, Mr. Jambo, you know Grace very well. And I believe Mr. Chigozi, you know Mr. Tumwesije very well. It is always good for the best person, because you know who is better than who. It's always better that the best person between you two presents first. You remind me of students who, remember when you were still learning in high school and university, someone is given 5 questions and they're supposed to answer 3, then they choose to start with their worst. Now when you start with the worst, I'm not referring to any worst here, but I'm just giving an illustration. When you start with the worst, you give an impression, you lower the standard. You get? So always start with the best oralist, because one may be good in writing, one may be good in oral presentations. So you want to give the judge an impression that this team is an A team. So start with the best oralist. Don't bring the best oralist last. Are you getting that? So I noted that you didn't pay attention to the details, and therefore you performed, but you would have done what? Better. And of course I expected you to in your submissions, I expected to hear things like, what is the problem from both sides? What problem are you addressing? What is the law regarding the problem that you're talking about? What are the minimum standards? What didn't the respondents do? And what did you do? You are rebutting. Okay? What is it that the law provides for? What is in existence? What is it that you want to see happen? Then I would have expected you to tell us what the minimum, the bare minimum, what the bare minimum is. Then what have you done? Why haven't you done what you should have done? You know, things of financial constraints and all that. I would have expected your submission to take that, so that there is coherence, there is the flow. The flow, someone can easily follow. But your issues were a bit mixed up, and maybe because you didn't follow the basics, because if you don't follow the basics from the word go, you end up mixing up issues. Yeah, so I hope those observations can help you improve in your next in your next round. Then in terms of individual performance, Mr. Jambo, in your first presentation, issues were a bit there. You had the law, but you were not very persuasive. You know, you can also win a case by just persuasion. You may know the law, but you have to be very, remember this is oral. oral, you have to be very persuasive. You saw how Mr. Tumwesuje was, he was trying to be, he may not even have submitted material things, but was a bit persuasive in his what? Presentation. Because you see, trial is about evidence. That's why you need to have mastered your facts so you can play around with the facts. The judges know the law. Yes, they want to hear the law, but can you bring out what is at hand in terms of facts? Are we together? Grace, I believe, Grace, you have a lot of potential. I think you just need to master your facts very well. Master your facts very well and also improve on the oral, but I believe you can do much, much better. Mr. Chigozi, you okay? I don't know, there's probably, you're too detailed, and I think you'll be a lawyer who wants POs, and you've already subjected yourself to this jurisdiction. Because if you say you don't have jurisdiction and then you continue submitting, the two don't. So can you concentrate on the issues, ignore what is not in issue, and concentrate on the problem question the way it was set, so that you don't waste a lot of time on things that are not really in issue. Mr. Tumwesije, I think you can do better. You can do better than that, but otherwise it was okay. So, in terms of individual performance now, scores, Mr. Ojambo, 75. Ms. Tubwite Grace, 86. Mr. Chigozi Herbert, 83. Mr. Tumwesije J, 88. Overall, applicants, 80.5. Overall, respondents, 85.5. I wish you good luck in your next round.
May we settle down, please? Welcome back, all of you, from the different rounds that we had. I hope everything went well. So a few things to note. One, we are waiting for everyone to come back, every team that is participating to come back to the room shortly. And once we are back, we shall invite the person who is compiling the marks behind. He's somewhere behind there. He will come in to announce to us your marks from the two rounds, the first and second preliminary rounds. Why? Because as he announces the marks, we shall need to get to know. Actually, he's going to come and announce to us the top 4 teams that have gone through to the semi-finals. But at the same time, we shall have a person who is going to write for you the marks for each team. And just to note that we shall be looking at the average of the first and second preliminary rounds per team. Okay? So he's going to come and announce to us the top 4 teams that have proceeded for the semi-finals. But we shall pin the marks for every team, your average mark or the marks that you got in each round for every team. Also, in the meantime, as we wait, after I'm done speaking, feel free to check